Hello, this is an introduction video of how to obtain a restraining order. A restraining order is an official document issued by a court to protect you against domestic abuse or harassment. All restraining orders begin with an application to the court which decides the merits of the request by using a traditional test. Now we'll go through three main steps of getting a restraining order. The first step in obtaining a restraining order, you can start the process by requesting a papers for a temporary restraining order. These papers are called the petition. You, the person completing the petition, will be called the petitioner. And the person you want the restraining order against is called a respondent. What do you say in the petition?
If you want to follow through with filing for a petition, you'll want to limit your statement to the incidents that caused you to want that restraining order. State exactly who, using the person's name, did or said what. Be specific about what happened. For instance, if you were threatened, state exactly what the person said or did that threatened you. If abused, state specifically what that person did to you. Also, you'll be required to state when the incident happened. Your petition will not be accepted if you don't provide proof of imminent danger to the court.
Next is the second step to get a restraining order. Once you file a temporary restraining order petition, the court will decide whether or not to issue a temporary restraining order based on the information you write in the petition. If the court grants the temporary restraining order, they will schedule a hearing for you to come back to the court within 14 days. This hearing is called an injunction hearing. How will the respondent find out about the petition you filed against them?
The sheriff will give the respondent the information about the petition and the injunction hearing date. This process is called serving the order or the service of process. The sheriff will serve the petition for free. The respondent must be served with the petition before the court can hold the injunction hearing, and it is your responsibility to get a hold of the police officer to make sure the petition is served. When the respondent is given the petition, he or she will read the statements that you wrote and be given the hearing date which he or she can show up to but does not have to.
The third and final step to trying to obtain your restraining order is going through the hearing process. Once the court schedules a hearing for you, there are some helpful tips to think about in order to make sure you're prepared. Here are a few things to keep in mind to help you feel more prepared for the hearing.
Get there a little bit early to make sure you can find where you're going. Practice what you'll want to say. Make a list of the orders you want and try not to ramble, but you are not limited on how long you can take. If you get nervous at the hearing, just read from your list. Use that list to see if the judge has made every order you asked for. Be prepared for the fact that during your hearing, the judge and the respondent may ask you questions. You may not always get the chance to rebuke all statements made. Your hearing can last anywhere from a few minutes to up to an hour. If the restrained person lies in court, wait until he or she finishes talking. Then, when it is your turn to speak, tell the judge about the untrue statement.
And we will now address some common questions regarding restraining orders. What are the most common parameters of restraining orders?
Domestic violence restraining orders are mainly designed to keep the restrained party away from you, but they can also provide other types of relief from abuse. Some of the requests you can make when filing for a restraining order include the following. A restrained person cannot contact you. The restrained party must stay at least 100 yards away from you. If you live with the restrained party, you can sometimes have the person removed from the property, but this is only effective if you have some claim to that property. You can request child custody, child support, and set a visitation schedule. Restrained party must be required to attend a batterer's treatment program in some cases. You may be able to get legal control of property that belongs to both of you or to you alone, and reimbursement for the cost resulting directly from injuries caused by the batterer, such as medical bills or lost income. Also, in domestic abuse and child abuse restraining orders, the restrained person cannot possess any firearms. What are the consequences of breaking these said parameters?
The law states that a person who violates a domestic abuse petition or injunction has committed a crime and may be fined up to $1,000, imprisoned up to 9 months, or both. It's important to keep in mind that a law officer can only arrest the respondent for violating the restraining order if the officer knows about the violation. It's important for the petitioner to contact the police anytime the respondent violates the restraining order, but if the respondent has fled and there is no other evidence that the respondent has violated the restraining order, it may not be possible for an officer to make an arrest. This is why you may want to tell a few people you work or live with about the restraining order so that others can call the police if they see the respondent going near you or can serve as a witness if they see something happen.
Does it cost money, and if so, is there financial aid available?
According to section 814.61 and 814.70 in the process for obtaining a restraining order in Wisconsin, no fees apply to filing for a restraining order against domestic violence, child abuse, or individual harm.
How old do you have to be?
You can file a restraining order once you turn 18, and child abuse restraining orders apply to people 17 and under.
And will I have to see my abuser in court?
It's his or her choice if they want to show up or not, so you may or may not see them in court. How long does a restraining order usually last?
A restraining order for domestic abuse generally can last for up to 4 years, but there is a new law that restraining orders can go up to 10 years if the court has reason to believe the respondent will be engaging in homicide or sexual assault.
Will I need an attorney?
You do not need an attorney to file a restraining order, and many people do so without the help of an attorney. However, if you are unsure about how the process works, it is a good idea to at least have an attorney to help you complete your paperwork. Can a restraining order keep the abuser away from my children?
Yes, in most cases, children in common can be protected by a civil restraining order, as well as children from a previous relationship and other household members. The judge can determine which parent the children should stay with. And when there are children involved, the judge will require both parents to talk to a family court mediator. Because you're asking for a restraining order, you're not required to have any appointment at the same time as your abuser. And the judge can also order the abuser not to take the children out of the county you live in without your written agreement or another court order.
Here's a quick recap on the steps to getting a restraining order. First, go to your nearest courthouse and file for a petition within which you will explain why you feel like you need that restraining order. Then, if the court decides to issue the temporary restraining order based on the petition you wrote, they will schedule a hearing called an injunction hearing for you to come back to court within 14 days. And lastly, have the petition delivered to the respondent and then begin preparing for the hearing. After the hearing, the restraining order go into full effect, and it will become illegal for the respondent to hurt you or even be near you.
In conclusion, a restraining order or protecting order is necessary for people who are the victims of domestic violence and individual violence. Wisconsin's restraining orders have proven to be a valuable tool in keeping people safe from abuse, neglect, and exploitation. If you feel like you have a reason to file for a restraining order, we suggest you do it. It's not as complicated a process as one might expect.